Have you ever thought to yourself, I could have invented that? I'm here with my colleague Chris Smits, who's also an expat here in London. He's a mechanical engineer and a U.S. attorney, as well as a qualified patent attorney with the United States Patent and Trademark Office. And we are near Wolverhampton, which is just outside of Birmingham, England, to my non-UK friends. And why we're here? Well, we're here to address that very question that a lot of people have in their life. I could have invented that. And really, the core issue of that is, in law, is it patentable? The patentability issue. And two very important elements of that, which are novelty and obviousness.
Right. And actually, patentability is 4 elements. And in most jurisdictions, those elements are, is it patentable subject matter? Right? Does it fall within the scope of things that people are allowed to patent? You're not allowed to patent laws of nature, abstract ideas, but basically in the US, everything else is fair game. So it's patentable subject matter. And then you have novelty or newness, as you mentioned, obviousness, and then finally it has to be useful, it has some utility to it. If it doesn't do what you say it's going to do, then it's not really worth anything. Now, I think the point is that these two most important aspects are novelty or newness and obviousness, because that's what I think most people think of when they think of an invention, right?
That's right. And the reason that we're here in Wolverhampton, of all places, is because we came across the most perfect thing to illustrate this issue. It's called horseboarding. What do horseboarding and patentability have in common? Well, that's a good question. A better question to answer that is, what is obviousness? When an invention is obvious to one skill in the art, you can't get a patent on it. Simple example, if I invent a cool computer and patent it, I can't add a power switch to it and just say that I've invented a cool computer with a power switch. Adding a power switch would be obvious. This comes up in patent litigation all the time because inventions are usually just small incremental steps in innovation. It's okay to combine things together that are not obvious and still get a patent. It gets really tricky though, because a layperson on a jury or a judge may not see how obvious the combination would be to a person who is skilled in the art, especially for high-tech innovation. To illustrate, that's where horseboarding comes in. Horseboarding is essentially chariot racing on a modified skateboard. It combines skateboarding, chariot racing, mountain boarding, and water skiing. Push on.
If you didn't know about all these sports beforehand, you would think that this is a truly novel and unobvious activity. But even if you did know about all these activities or sports beforehand, you might still think it's novel, new, non-obvious. That's the tricky part.
Okay, so kids have been catching rides behind bikes and cars on their skateboards for decades. Off-road skateboards have also existed for decades. And well, chariot racing is millennia old. So is it really novel to combine these things? Maybe, maybe not.
Right. That's the thing with innovation. Taking known devices and combining them so that they can do something new and innovative. It's the whole ball game when we're talking about obviousness, especially. To a person with skill in the art of horse riding, but not skateboarding, maybe it would be. However, to someone with skill in the art of skateboarding, all you did is replace the bike with a horse. So, not that, non-obvious. Now, from the eyes from a chariot racer, a chariot with a skateboard. It all kind of goes together.
Right. And the thing that is of import right here is that depending on whose point of view you're looking at, this sport is either novel or it's not. In law, that person who knows what's going on in the art is called the person with skill in the art. For horseboarding, there are not a lot of horseboarders, but there are a lot of chariot-style racers. So we've actually asked Daniel and Emma, who are our kind hosts today, to join us to talk a little bit about their gear, because in this field, if anybody is skilled in the art, it's them. So please guys, why don't you tell us a little bit about your boards and some of the gear that you've developed for this.
We take a mountain board with a skateboard style truck, and we modify our boards with a mountain bike computer so that we can record our speeds, we can record our maximum speeds, and we can, if we so wish, record our lap times. We then, to allow us to tow from a horse, we take something similar to a water ski handle. We considerably shorten the length, normally 70 foot for a water ski, down to probably 12 foot for our purposes, and we combine that with a quick release mechanism so that we can always quickly disconnect from our horse. And then where we've been slightly innovative is with our harness which we attach to our horse's saddle. Now this is a salt harness which we have developed because nothing exists to connect our rope to a horse, because clearly no one has ever wanted to be towed by a horse.
Now, Daniel and Emma, you were saying that this is actually something that you guys innovated, right?
Yes.
Yeah.
And for our watchers back at home there, what you need to know is now that they've disclosed this to the public, which wasn't us first, by the way, they have 1 year to go ahead and get this patented. Otherwise, it will lose its patentability based on that technicality. So, highly suggest that you take this to a lawyer and get this thing patented if you're so interested, all right?
I believe that will be our next move.
All right. Well, thanks a lot, guys.
Thank you very much.
I once had a case where the patent was for adding a password to a SATA storage device. The patent claimed that SATA, or SATA, existed, but adding a password to access the document on the system was novel to prevent more than one person working on a document at a time. They tried to make it look really novel by making the password concept seem really complicated, but it wasn't. It was simply using an existing technology to lock out other editors while the document was in use by another person. It was useful for document control, but it wasn't novel. In my experience, if you're linking more than 3 things together, then a judge or a jury is not going to think that this idea was obvious. There's just too many things being pulled together, especially when you're pulling ideas from different disciplines.
That's right. Also, you run into situations where a piece of prior art, a magazine article or a newspaper, a journal, whatever it might be, a specification for a new technology, there's going to be a hint in that publication that basically takes you to the edge of the current technology, but suggests, well, wouldn't it be great if we could do this as well? And when you come to something like that, you know that people who are skilled in the art and familiar with the technology are going to have read that, and whatever that may be now is not going to be patentable.
Finally, the distinction between US and EU patent law highlights this problem. US patent law requires an invention to be non-obvious. European patent law requires an invention to involve an inventive step. While this may seem at first to be essentially the same, there are important differences. In Europe, the examiner determines what the differences between the invention and the prior art are. If there are none, the invention is not novel. If there are, the examiner determines what technical problem is solved by adding these elements to the prior art system. He then determines if solving the technical problem by adding those elements would be obvious. If no technical problem can be found, the invention does not involve an inventive step.
Confused? You're not alone. When presented with competing evidence, it really comes down to a gut level belief in one party's expert over another. There is some relief though.
As a matter of fact, just recently, a couple months ago, the U.S. Supreme Court confirmed that clear and convincing evidence, a very high burden of proof, is required to invalidate a patent. So if you think that something's on the border with this, whether it's obvious or not, know that in a court of law, you're going to be given basically the benefit of the doubt that it is patentable. In conclusion, we've had a wonderful time with our hosts here in Wolverhampton, and I've had a great time with Chris.
Yes.
We've learned the basics of these issues of patentability, novelty, and obviousness, and we've learned it in a really great way. I hope you've enjoyed it, and I want to thank you, Chris, for joining me.
You're welcome. My pleasure.
Got it.